How does one prove false allegations of parental alienation in a child custody dispute? Answer: with great difficulty in most, if not all, cases. Quote, "It used to be a fashion amongst men that when a charge was made, some sort of proof was brought forward to establish it, and if no proof was found to exist, the charge was dropped." Close quote. Abraham Lincoln. Few courts are slaves to such fashion today when it comes to allegations of child abuse, and parental alienation is a form of child abuse. Even if the term parental alienation is not codified, manipulating a child to fear and hate a parent is emotionally and psychologically abusive in anyone's book. Many courts treat evidence differently when dealing with matters of child custody. They're not allowed to do that, but that doesn't stop them. It's as though they feel when it comes to matters involving children that the preponderance of evidence standard, which is the one that applies, is somehow not good enough, not safe enough. If an allegation of child neglect or abuse is made, many courts get scared. Not necessarily scared for the health and safety of the child, however, but for the safety of their own careers. There is an enlightening article on domestic violence restraining and protective orders, to which I have provided a link in the description section of this video, that's enlightening on this subject. The article explains the problem and its adverse consequences when judges apply different standards when they're not allowed to. In a nutshell, many judges and other judicial officers analyze claims of child abuse this way. For example, if I make findings and enter orders that treat the accused parent as abusive, then nobody can fault me for failing to protect the child. Better safe than sorry. But if I don't issue such an order because I find the accusing parent failed to meet his or her burden of proof, and then later the accused parent is caught committing child abuse or new evidence comes to light proving that he or she was abusive in the past, then I look like I wasn't paying close enough attention. And that's not fair, and it's not. I agree. That somehow I am incompetent, or worse, that I did not care about child safety and welfare. And that's a fair complaint. It's a legitimate concern. And so what a lot of judges do is say, better to nip that problem, for me, the judge, in the bud and just err on the side of caution. Now, can you see the damage done when judges think and act this way? Protecting a child from a parent who has done no harm, who is innocent, results in 3 victims: the innocent parent, the innocent child, whose relationship with the parent is now seriously damaged, if not destroyed, and the child's, the parent's, and the public's trust in the judiciary and faith in the impartial administration of justice. What kind of respect for law and order are parents and children who were victimized by a self-serving, cowardly judge going to have? James Madison put it perfectly. Quote, "We are to look upon it as more beneficial that many guilty persons should escape unpunished than one innocent person should suffer. The reason is because it's of more importance to the community that innocence should be protected than it is that guilt should be punished. For guilt and crimes are so frequent in the world that all of them cannot be punished, and many times they happen in such a manner that it is not of much consequence to the public whether they are punished or not. But when innocence itself is brought to the bar and condemned, especially to die, the subject will exclaim, 'It is immaterial to me whether I behave well or ill, for virtue itself is no security.' And if such a sentiment as this should take place in the mind of the subject, there would be an end to all security whatsoever."